20 Ming Tsoi vs. CA and Gina Lao Tsoi. GR number 119190. January 16, 1997. Facts. On May 22, 1988, plaintiff and the defendant got married. Although they slept in the same bed since May 22, 1988 until March 15, 1989, no sexual intercourse took place. Because of this, they submitted themselves for medical examinations. She was found healthy, normal, and still a virgin. Her husband's examination was kept confidential. The plaintiff claims that the defendant is impotent, a closet homosexual, and that the defendant married her, a Filipino citizen, to acquire or maintain his residency status here in the country and to publicly maintain the appearance of a normal man. The plaintiff is not willing to reconcile with her husband. The defendant claims that should the marriage be annulled, it is his wife's fault. He claims no defect on his part, as he was found not to be impotent, and any differences between the two of them can still be reconciled. He admitted that they have not had intercourse since their marriage until their separation because his wife avoided him. He added that his wife filed this case against him because she is afraid that she will be forced to return the pieces of jewelry of his mother, and that the defendant will consummate their marriage. The trial court declared the marriage void. On appeal, the Court of Appeals affirmed the trial court's decision. Hence, the instant petition issue. Whether or not petitioner is psychologically incapacitated. Ruling: yes. Senseless and protracted refusal to consummate the marriage is equivalent to psychological incapacity. Appellant admitted that he did not have sexual relations with his wife after almost 10 months of cohabitation, and it appears that he is not suffering from any physical disability. Such abnormal reluctance or unwillingness to consummate his marriage is strongly indicative of a serious personality disorder which to the mind of the court clearly demonstrates an utter insensitivity or inability to give meaning and significance to the marriage within the meaning of Article 36 of the Family Code. Petitioner further contends that respondent court erred in holding that the alleged refusal of both the petitioner and the private respondent to have sex with each other constitutes psychological incapacity of both. However, neither the trial court nor the respondent court made a finding on who between petitioner and private respondent refuses to have sexual contact with the other. But the fact remains that there has never been coitus between them. At any rate, since the action to declare the marriage void may be filed by either party, the question of who refuses to have sex with the other becomes immaterial. One of the essential marital obligations under the Family Code is to procreate children based on the universal principle that procreation of children through sexual cooperation is the basic end of marriage. In the case at bar, the senseless and protracted refusal of one of the parties to fulfill capacity. The petition is denied.